the Creative Employee Benefits Compliance webinar. My name is Kevin Knopf, and I am Vice President of Communications for Keenan, and Accretive company. Accretive is comprised of more than 40 specialty companies with offices in the US, UK, and Ireland. Our capabilities extend beyond traditional insurance offerings. Accretive specializes in cost-controlling solutions that encompass comprehensive enrollment services, medical stop-loss programs, and pharmacy benefits management. These services are designed to manage risks effectively while optimizing costs, ensuring that both employers and employees receive the maximum value from their benefits plans. This month, we'll be covering our mid-year benefits election changes. Presenting again today is my good friend and colleague, Amy Donovan. Amy is Senior Vice President and Chief Counsel of Employee Benefits Compliance for Accretive and is our primary source for legislative and regulatory research, analysis, and advocacy. She's been instrumental in guiding our clients and internal teams through the complex legislative landscapes and meets regularly with federal lawmakers, lobbyists, thought leaders to discuss national trends and health insurance issues. Before we begin, I'd like to remind you that this webinar is for informational purposes only and does not constitute legal advice. You should consult with your own legal counsel before taking any actions based on the information presented here. Also, please note that this webinar is being recorded and will be available on the Keenan and Accretive websites for future reference. If you have any questions during the webinar, please use that QA button at the bottom of your screen. If you have any technical problems, you can use the chat feature. Without further ado, I'd like to introduce Amy.
Thanks, Kevin. And hi, everyone. Today, we are going to be talking about mid-year election changes. There are some general rules, and then we're going to be talking about different types of plans and how the rules interact with those different kinds of plans. So let's get going. So in terms of general rules, this is one of the areas, and I would say this is the area where we get the most questions from plan sponsors. It just comes up a lot in your work, and the rules are complicated. They're long. There's a lot of different aspects of them. So I'm going to try today to break it down for you in a way that simplifies things a little bit, makes it make sense to you. And then we're going to go through a few examples at the end. So an employee comes to you in HR or in benefits and says, can I change my elections? Something has changed in my life and I want to change what I elected during open enrollment. So this is really governed by IRS rules, and that's because when they are making elections under a cafeteria plan, they're making elections for using their pay to pay for their benefits pre-tax. It's a tax benefit for your employees, and therefore the Internal Revenue Code is going to govern when your employees can pay for benefits using pre-tax dollars. And the section of the Internal Revenue Code that governs that is Section 125. Section 125 says that pre-tax elections generally must be made prospectively for the future, and they are irrevocable unless they're allowed under the election change rules. So Section 125 rules govern whether pre-tax contributions can change. That is actually a separate question from whether the carrier will allow a mid-year change. So you may have a carrier that says, sure, you can take that person off the plan. But under the IRS rules, you also have to determine whether you can allow that person to, for example, lower their pre-tax contributions because they're taking that person off the plan. So this is a little bit of the tail wags the dog, but this is the most important part. The pre-tax election is what people really are attempting to change most of the time. So there are a couple of sources, really only two sources of election change rules. There's the Internal Revenue Code, Section 125, and its regulations and other IRS guidance. So there's all of those IRS rules. And under the IRS rules, the employer has to choose to allow certain types of changes. So if it's 125 rules that we're talking about, the employer has to make a decision before the plan year begins and put in its written plan document what it will allow of the Section 125 rules. Now, as a matter of practicality, most employers that I work with allow all of the changes that are allowed under Section 125 rules, and that's essentially what their 125 cafeteria plan document will say, that they will permit election changes that are done consistently with Section 125 rules, and that's fine. If an employer wants to make a different decision, if there are certain kinds of changes they don't want to allow, they generally can do that. The only exception to that is the HIPAA rules, and these are HIPAA election rules that are for medical, dental, and vision plans only. So let's first look at Section 125 election changes. So as I said, it has to be written in the cafeteria plan document to be allowable under the plan. So your first question always when looking to figure out whether an election change is possible is, what does the plan say? And again, with the exception of HIPAA special enrollment rights, mid-year election changes are permitted only if they're included in the written 125 document. And then the next question is, what plan election is being changed? And the reason is allowable or not, depending on the type of benefit that you're talking about. Here is just a summary of the reasons that, that come up and whether they're allowed for particular benefits. And this doesn't include everything that's available under a 125, but these are the basics that we get questions about all the time: medical, dental, and vision plans, health FSAs, and dependent care FSAs, or DCAP plans. So let's talk a little bit about the medical, dental, and vision plans. Those plans have the most allowable changes. And the first one is HIPAA special enrollment rights. And we're going to talk about those a little bit more in a minute. Also, change in status events, cost changes, coverage curtailment, FMLA leaves, significant improvements in coverage, changes under another employer's plan, a loss of governmental or education provided coverage, and exchange enrollment. So a person's enrollment on an ACA exchange, Medicare or Medicaid entitlement, COBRA qualifying events, and judgments, decrees, and orders. So I wanted to spend a few minutes distinguishing a little between HIPAA special enrollment rights or change in status changes. And they're very similar. The categories overlap. And it really comes down to whether you're adding a change or adding a benefit or adding a person or subtracting. So let's talk about HIPAA special enrollment rights. Under HIPAA, employer plans, that is medical, dental, and vision plans, so group health plans, are required to allow mid-year enrollments and make the corresponding change to an employee's pre-tax election for essentially three categories of additions. Life events. So the person has gotten married, added a new child to the family, either through birth or adoption or placement for adoption. They've had a loss or gain of eligibility for CHIP or Medicaid coverage, or they've had a loss of eligibility for other employer coverage. And we'll go through that a little bit more on the next slide. Those are the categories for which, if somebody wants to add a person to their plan, HIPAA says that employers need to make those changes. There is a time limit for these changes. So the employee needs to give you notice within 30 days if they're making the change because of a loss of other employer coverage or because of life events, that marriage, birth, adoption, placement for adoption. The time is a little bit longer for loss or gain of eligibility for CHIP or Medicaid. That's 60 days. And the other thing that's important to understand here is that these changes are prospective only, with one exception. And the exception is for a new child added to the family by birth, adoption, or placement for adoption. For that, the coverage and the pre-tax election goes back to the date of birth or the date of adoption or placement for adoption. So you remember on the last slide, I'm going to go back for a second. I said that we would talk a little bit more about loss of eligibility for other employer coverage. So what does that include? Well, these examples come straight from the regs, and it includes divorce or legal separation, which results in the employee losing coverage under a spouse's health coverage, or if a dependent is no longer considered a covered dependent under a parent's plan because maybe they've aged out, or if a spouse's death leaves the employee without coverage under a plan, the spouse's employment ends, as does coverage under their employer's health plan. The employer reduces an employee's work hours, causing the employee to lose eligibility for a health plan, or the plan decides it will no longer offer coverage to a certain group of individuals, for example, those who work part-time. Or an employee no longer lives or works in the HMO's service area. So these examples are set forth right there in the regs. Those are examples of when a person loses eligibility for other employer coverage under the HIPAA special enrollment rights. Now, what we've just talked about is going to sound very familiar when we talk about Section 125 change in status events. So under 125, you can add or take somebody off the plan and change their pre-tax election based on a change in legal marital status: marriage, death of the spouse, divorce, legal separation or annulment, a change in the number of dependents by birth, death, adoption, or placement for adoption, a change in employment status of the employee, spouse, or dependent. So that's termination or commencement of employment, a strike, a lockout, commencement or return from an unpaid leave of absence, a change in work site, any change in employment status basically that affects eligibility under the plan. Or the fact that the dependent satisfies or ceases to satisfy eligibility requirements due to age, student status, etc., or a change in residence for the employee, spouse, or dependent. That looks an awful lot like the HIPAA special enrollment rights list, right? It feels very similar. And essentially, the difference will be that if somebody wants to add someone to the plan, you have to allow it under the HIPAA special enrollment rights. If somebody wants to take somebody off the plan or make another change based on these life events, then that is allowable by the plan if they allow it under the plan document. As a practical matter, almost every plan does allow this under the plan document. But again, it has to be written in your written cafeteria plan. Another thing to consider when talking about change in status events that's important under 125 is that the change in status has to be consistent with the change that they're looking to make in their elections. So for a change in legal marital status, the number of dependents, the employment status, the dependent eligibility, or change in residence, if these are the reasons why a person is making a change in their elections, then the election change has to be made on account of and correspond with the change in status that affects eligibility for coverage under an employer's plan. So it has to match up. It can't be just an excuse to make another change in their elections that has nothing to do with and wasn't affected by the change in status reason. So with that, those are the two biggies: the change in life events and the HIPAA special enrollment rights. But there are other reasons under Section 125 to make a change, and we're going to go through those now. So this is one we deal with often, and that's cost changes under Section 125. Changes to pre-tax elections under the rules will be automatic if the cost of a qualified benefit plan increases or decreases during the period of coverage. So if, for instance, you have a mid-year change in premium and it decreases, and therefore everybody has elected an amount that is more than actually they have to pay, then you can automatically lower everybody's election for that plan to match the premium decrease. That doesn't have to go through any sort of other process. That's allowable under Section 125. The other category, and the one that we get asked about more often, is significant cost changes. And what the rules say is that an employee can make a corresponding change, including switching to a lower cost coverage or even dropping coverage, if there has been a significant cost change under the plan. The issue with this reason is that the IRS rules do not specify what a significant change is. IRS examples have used 12.5% as an example of a significant cost change. However, the IRS has also said that 12.5% isn't necessarily the bar or the standard. So certainly if there's a change of a 12.5% increase or decrease, you've got that IRS rule right out there. But sort of where the change becomes significant is an area that is a little more gray. There are also rules that allow changes to be made when there have been coverage changes mid-year under the plan. And there are two kinds of coverage changes. There's a significant curtailment of coverage, so pulling back of coverage, or a significant coverage improvement. For significant curtailment, there can be a loss of coverage. So you can have a significant curtailment with a loss of coverage, which the rules give examples of: elimination of a benefits package option, or an HMO ceasing to be available where the person resides, or a substantial decrease in medical care providers under the plan. So for instance, a major hospital in the area where the plan is available ceases to be part of the plan. Or a reduction in benefits for a specific type of a medical condition or treatment that the employee or their dependent is utilizing. So those would be significant curtailments with a loss of coverage. There are also significant curtailments without a loss of coverage, and those would be significant curtailments with that are also a significant increase in a deductible, a copay, or out-of-pocket cost sharing limit. And the regulations note that usually the loss of one physician in the network, even if it's the person's primary physician, is not enough to be a significant curtailment. So those are situations which, if they are allowed under the plan document, a change can be made. There are also situations in which there has been a significant coverage improvement mid-year, an addition or improvement of a benefit package option. That also would correspond with an ability to change elections under the plan to opt into that improved benefit package option. Another reason that people can, under the rules, and that employers can allow people under the rules to make changes in their Section 125 elections is exchange enrollment. And there are a couple of ways that are specified in guidance that was enacted after the 125 regs. There's actually two sources of guidance: a 2022 notice and a 2015 notice, I believe, that state that a reduction in hours of service without a loss of coverage for an employee whose hours are reduced to below 30 hours a week, that is below the full-time status for ACA purposes, but they have not yet lost coverage because they're in a stability period over the plan. So this is a person who has not lost coverage yet. Their hours have been reduced. Once they're through the stability period under your plan, they will lose coverage because they have lost the hours. That's a situation in which IRS rules say that that person can be allowed out of the plan and stop making a mid-year election if they are moving then to exchange enrollment. There's also enrollment in an exchange qualified health plan for an employee who qualifies for either a special or annual enrollment period in the exchange. So an employee can revoke their election under the group health plan to enroll in the exchange plan so long as the election change corresponds to the intended enrollment of the employee and their related individuals, so spouse and dependents, in individual coverage. And the third situation in which you can allow somebody to change their elections mid-year for exchange enrollment is if they are is a revocation of other than self coverage, so a revocation of family coverage. And an election of individual coverage to allow family members to enroll in qualified health plans through the exchange. These changes were made within the last 10 years. They were not originally part of the Section 125 rules, but these changes were made in light of the ACA and the existence of the exchange. And your plan can allow employees to make these changes if it is in your plan document. There are other permitted reasons that are simpler to explain and that come up less often as well. So there is FMLA. An employee taking an FMLA leave may revoke an existing election or cease payment for the time that they are on leave, if that is provided for in your plan document. You can also give somebody an ability to make an election change if there's been a change on another employer's plan. This happens often. The change must be on account of and correspond with the change in the other employer plans. So again, there has to be that consistency between the change and the change in situation and the change in election. Loss of governmental or educational coverage is another one. So the example for that would be a loss of coverage under a state risk pool or a tribal government plan or a college health plan or SCHIP. You can also allow a person to change elections mid-year if they are dropping coverage because they have enrolled in Medicare or Medicaid, or enroll in the plan and start a mid-year election, increase your mid-year elections if the person loses coverage under Medicare or Medicaid mid-year. COBRA qualifying events are also reasons for a mid-year election change, and decrees and orders. So those are the ones that are usually resulting forced legal separation, annulment, or a change in legal custody. And you as the employer would be presented with a qualified domestic relations or quadro or something similar. So those are the rules in place for medical, dental, and vision. Let's talk a little bit about FSAs, HSAs, and group term life. So for a health FSA, an election change is permitted for change in status events like the ones we went over earlier. For FMLA leave, for Medicare and Medicaid entitlement, for COBRA qualifying events, and for judgments, decrees, and orders. But it is not permitted under IRS rules for cost changes, coverage curtailment, or significant improvements in coverage. One type of FSA is a dependent care FSA, and there are some different rules for dependent care FSAs. So a change in elections is permitted for change in status events, for FMLA, and for cost changes, as long as those cost changes are with a non-family member provider. That is, it's not you're paying your mother or your aunt to take care of your child if you're the employee. So it's cost changes with somebody who's not a member of the employee's family, who is the caretaker that's being paid. Or changes in provider or hours are all reasons to allow an employee to change their elections under a dependent care FSA mid-year. They are subject to the consistency rules. So the election change is permitted if it is on account of and corresponds with a change in status that affects either eligibility for coverage for qualified benefits or expenses that are described in Section 129. So employment-related expenses as defined in Section 21B2. This is the section of the Internal Revenue Code that establishes dependent care plans with regard to dependent care assistance. So as long as it's an eligible expense under dependent care rules, if there has been a change in that eligible expense, you can make your employee can make a change in their pre-tax election. If they have had a change in eligibility, they no longer have a need for dependent care because their co-parent has decided to be at home full time taking care of the child. That's a change in eligibility for coverage, and they can make a change in election under the dependent care plan. There are special rules for other account-based plans. For HSAs, actually, the rule is much broader. Under an HSA, changes can be made prospectively on a monthly basis. For adoption assistance, which is also a kind of flexible spending account that we see, mid-year election changes are allowed for the commencement or termination of an adoption proceeding. Again, with adoption assistance, there is a consistency rule, but it is satisfied if the election change is on account of and corresponds with a change in status that affects either eligibility for coverage under the plan or qualified adoption expenses, which are described in Section 137 of the Internal Revenue Code. And finally, for group term life plans, an election change is permitted only if the change is on account of and corresponds with a change in status that affects eligibility for coverage for a qualified benefit under employer change plan. So it includes a change in status that results in an increase or decrease in the number of an employee's family members or dependents who may benefit from coverage under the plan, or an election to increase or decrease coverage in response to a change in status event that is deemed to correspond with a change in status. So with those basic rules in mind, we're going to pull it together with a few examples. These examples are not, they weren't made up by me, although actually no part of them were made up by me. They come straight out of the Internal Revenue Code's regulations, which are filled with examples. I would actually encourage any of you who are who have questions about election changes to take a look at the election change regulations. There are a ton of examples there. I have jazzed them up a little bit with some TV show examples, just to put faces to this. The IRS has this way of explaining things with employee A and employer X, and I don't think it aids understanding, and it's also just really boring. So with that, we're going to have our first example. And actually, I'm going to ask Kevin to come back on camera and be my employer
Great.
for the day. Um, so this example comes from Mad Men. So Sterling Cooper Advertising Agency provides health coverage for its employees under a plan through which employees may elect either employee only or family coverage. Sterling Cooper also maintains a calendar year cafeteria plan under which qualified benefits, including health coverage, are funded through salary reduction. So Sterling Cooper employee, Don, is married to Betty, and they have a child, Sally. In accordance with Sterling Cooper's cafeteria plan, employee Don elects employee-only health coverage for the beginning of the calendar year. During the year, Don and Betty adopt a child, Donnie. Within 30 days thereafter, Don wants to revoke his election for employee-only health coverage and obtain family health coverage for Betty, Sally, and Donnie as of the date of Donnie's adoption. So the question is, can Don do that?
So this is totally not rehearsed, right? We didn't do that. The first thing I thought you were going to ask when you brought up Sterling Cooper is something about liver coverage. But
Yeah.
no, I would think yes.
Yes, you're right. They can. So Sterling Cooper's cafeteria plan may permit Don to change his salary reduction election to family coverage under HIPAA special enrollment rights. They have added a member to the family through adoption. The increased salary reduction is permitted to reflect the cost of family coverage from the date of adoption. Don's adoption of Donnie is also a change in status, and the election of family coverage is consistent with that change in status. So Sterling Cooper's cafeteria plan could permit Don to elect family coverage prospectively in order to cover Betty, Sally, and Donnie for the remaining portion of the plan year. So hooray, you got one right. 3 more to go, Kevin. You ready?
Not really.
Okay. Example 2 is transfer out of HMO service area. So this one is from my current favorite TV series, Severance. Lumon Industries maintains a calendar year cafeteria plan under which full-time employees may elect coverage under one of 3 group health plans, a PPO, or either of 2 HMO options with different service areas. Lumon also offers a health FSA. They're very generous at Lumon. Mark S., who works in the service area of HMO number 1, elects the HMO number 1 option. During the year, Mark is transferred to another work location, which is outside the HMO number 1 service area and inside the HMO number 2 service area. So the questions, there are 2 questions. Can Mark make an election, and what changes can he make?
Can Mark make an election change?
Yes.
I would think he could switch to a PP. It depends who's deciding, is innie or is outie. I think he could switch to a PPO or maybe stick with his HMO one and drive really far for care.
He can switch actually to either of the other plans, the HMO or the PPO plan. So let's see. So Mark can change his group health plan option. The transfer is a change in status, being a change in work site. And under the consistency rules, the plan can allow Mark to make an election change, either to elect the PPO or HMO2, or to cancel group health coverage altogether. Mark cannot, however, change his FSA election. The change in work site has had no effect on Mark's eligibility under the Lumon FSA, and so no change in Mark's FSA is authorized.
That makes
He
so much
may,
more sense.
however,
When you
get
read
a fruit salad party though.
and some goats.
And that is not run through the cafeteria plan. Okay, so example number 3 is a mid-year premium reduction, and this is from Abbott Elementary. So Janine is a teacher at Abbott Elementary School. Abbott maintains a calendar year cafeteria plan pursuant to a collective bargaining agreement for the benefit of Abbott employees. The cafeteria plan offers various benefits, a group health PPO and a health FSA. As a result of mid-year negotiations, the premiums for the PPO plan are reduced in the middle of the year. Insurance co-payments for office visits are also reduced by an amount which constitutes a significant benefit improvement, and an HMO option is added. So my question is, what changes, if any, can Janine make to her elections mid-year?
I should have read these in advance since I had the slides and I didn't. If I had some savings from premiums dropping, I just buy coffee and not worry about it.
You want me to just go straight to the answer on
No,
this one?
I'm going to say she could probably she can reduce salary contributions and or switch to the new HMO, but she can't change her FSA elections.
Yeah, let's look. You were right.
All right.
The reduction in health insurance premiums is a reduction in cost. Accordingly, the cafeteria plan can automatically decrease the amount of salary reduction contributions of Janine and the other affected participants by an amount that corresponds to the premium change. Also, the decrease in co-payments is a significant benefit improvement. And the addition of the HMO option is an addition of a benefit package option. So therefore, the plan can permit Janine to make an election change to elect the indemnity plan, that is the HMO, that is the PPO, or the new HMO option. Finally, the plan may not permit Janine to change her health FSA election to reflect the mid-year change in co-payments under the PPO. So I don't know, you're doing really well so far. We have just one more for a perfect score, Kevin. You feel ready?
No.
Okay. This is a dependent care option, dependent care example, rather. And the TV show is Brooklyn Nine-Nine. So Jake is married to Amy and they have one child. Their employer, the New York City Police Department, maintains a calendar year cafeteria plan that allows employees to elect coverage under a dependent care FSA. Jake and Amy's baby is cared for by Doug Judy, which may reflect some very poor judgment on their part, but that's beside the point. Doug Judy, Jake and Amy's household employee, is not a relative of theirs and provides child care services at an annual cost of $4,000. Prior to the beginning of the year, Jake elected a salary reduction contribution of $4,000 to fund coverage under the dependent care FSA for up to $4,000 of reimbursements during the year. During the year, Jake raises, it says Z there. See, that's from the IRS, but it's Doug Judy. So Jake raises Doug's salary. Jake now wants to change his dependent care FSA election for the year to an annual amount of $4,500 to reflect the raise. So the question is, can Jake do this, or is he flouting the rules once again?
Okay, so one, I'm pretty sure I know this one. You added this morning and I didn't read this example yet. You've hit all my favorite TV shows. Why is the Pontiac Bandit babysitting? There's a whole other question.
I'm telling you, well, because Jake has very poor judgment.
Yeah, very. I would say yes, the raise is a significant cost increase, so the plan may allow Jake to increase his election.
He can do it. Because under the dependent care rules, if there has been a change in the cost of coverage, childcare coverage, then you can make a change in the election, so long as the person that's taking care of your child whose price has changed is not a relative of yours. So the answer is Jake can do that. Doug Judy's salary increase is a significant increase in cost, and an increase in election to change and an increase in election change to reflect the raise corresponds with that change in status. So the NYPD's cafeteria plan may permit Jake to elect to increase his election under the dependent care FSA. So you are 4 for 4, my friend. I'm very impressed, especially since you didn't even set eyes on a couple of these examples.
Yeah, I don't know what I feel. I'm not usually doing this, so.
So there are, I know a lot more examples of this. I'm sure that a lot of you have questions and we have some time. So I'll first read the disclaimer and then we'll take a look at your questions and see if there are any that we can answer live. If we don't get to your questions today, please make sure to follow up with your creative agent or broker, and they will be able to get answers to you. And we, depending on how many of these extra questions we get, we may send out some FAQs on this as well. With that, accretive companies are insurance brokerage and consulting firms. The accretive companies are not law firms or accounting firms. We do not give legal advice or tax advice, and neither this presentation, the answers provided during the Q&A, nor the documents accompanying this presentation constitute or should be construed as legal or tax advice. You're advised to follow up with your own legal counsel and or tax advisor to discuss how this information affects you. And I would add, as an attorney, that if you have a particular situation with an employee where you are, it's important that you seek advice from your own counsel with whom you have attorney-client privilege, who has full knowledge of the ins and outs of your situation and who can provide you with legal advice. So with those caveats, I'm going to ask if there are any questions, and
There are quite
I'm
a
going to.
few.
Okay, great.
So we'll start off, I can throw one at you here. Is
Okay.
the Section 125 document customized by the employer, or is it standard template provided by the IRS?
It's not a standard template provided by the IRS. For most employers that have an FSA, their FSA company will provide them with a sort of template document. But and usually those template documents provide that the employer will allow any election changes that are allowable under IRS rules. But it can be customized by the employer. For ERISA covered employers, usually whoever authors your SPD can will include your cafeteria plan documents along with your ERISA plan documents. If you're not ERISA covered, if you're a government institution or a church plan, you need to make sure that you have a written cafeteria plan in place, and certainly your agent or broker can help you to find somebody to do that for you.
Great. The next question, perfect for me. I have a one college student, one off to college in a year. Does a change in student status, is that an ACA change?
Is it an ACA change?
That's how the question's written. Is it
Okay.
a qualifying event?
A change in student status under a group health plan under the ACA now is really not usually an event that would trigger an election change, because your dependent children can stay on the plan up to age 26 regardless of student status. So that may apply with other, and I'm trying to think if there's another option under cafeteria plans where a person's student status may come into. I can't think of one off the top of my head. So that part of the rule may have predated the ACA. Generally speaking, you're not going to, unless your plan allows people to stay on the plan past 26, if they're a student, then that would, if you have a sort of unusual plan, that that is dependent in part on student status, then possibly that could be a reason for a change in election. Or if the person lost coverage, so if the dependent had coverage through their college health plan and they lost their student status, they will have lost coverage under an educational institution plan, and that is a reason to add them as a dependent mid-year.
What if they're, I have a student that goes to college in another state and the coverage is inappropriate? That's a change that would be a qualifying.
Because the
My
student would no
insurance,
longer,
my
yeah,
student's covered under me, but he's moved away and there's not adequate network coverage there.
correct.
Next question here, and this was actually addressed in the examples, I believe, but it's worth repeating again. Elaborate on change in residence. The question was, for an eligible status change for 125 plans related to a change in residence, can someone move, if someone moves, can they reduce or increase their FSA?
No.
Right, and we covered that in the example. That it could affect their regular benefits, but their medical benefits, but not their FSA coverage.
Right. And somebody moving in and of itself does not automatically trigger an ability to change your elections. The move has to correspond to a change under, you know, a change in your ability to access benefits under the plan, essentially. So you've moved out of an HMO service area, or you've moved away from the area where the network is, you know, where most of the network providers are located. So again, those consistency rules are really important to consider when going through any example.
What if a reduction in hours is an increase in cost, but not a loss of coverage? Is that a qualifying event?
So the person
A reduction in
loses.
hours is an increase in cost, but not loss of coverage. So they have an income loss.
So
It's an interesting question how it's worded, so I'm not quite
yeah,
sure.
I'm not sure. That's one I will have to, I think I would need more details on that. I think a significant cost increase would, yeah, I'm not sure. Wait, let me go back. I'm not gonna like make you all dizzy by going back through all of these. Well, yeah, we'll put a pin in that one. That's a really good one, and I think maybe I will we can look at that one for a for a Q&A on the blog sometime soon.
Here's a specific question that was submitted. I have an employee who accidentally signed up for the dependent care FSA during open enrollment and discovered mistakenly recently that they had accidentally signed up for it. The employee now wants to transfer all that money contributed into their FSA.
Um, you might be able to undo the election of the dependent care. You're not going to be able to put those funds into an FSA mid-year just because the employee made a mistake.
All right, next one. I told you there's a lot of these today.
Yeah.
Related to qualifying event for coverage changes, would that apply to a change in the rollout for California infertility coverage? The example that this person submitted was, so if they have Anthem, which is not offering the infertility coverage yet, and that employee wants to change to Kaiser that has the infertility coverage already, would that be considered?
That might be a significant increase in coverage that because it became available mid-year under the plan. Potentially they would be able to do that.
All right, let's see what else is here. We've addressed some of these.
Yeah, let's see if we can get one more good one.
If your husband immigrates to the country outside of open enrollment, is that
Mhm.
considered QLE moving into coverage area?
Huh. So it's not a new marriage. You're not adding the person because you just got married. You're adding the person because they've now moved into the coverage area.
But this says immigrates to the, oh, yeah, yeah,
Yeah.
yeah, yeah.
Um, that's another one that I'm not, I think yes. I would have to go back and take that through the rule, but I think the answer to that is probably yes.
All right, I got a couple more. There's a lot more here, but I think we have time for a few more here.
Okay.
This one is our benefit plan runs July to June, open enrollment in June. One of our unions is advising us that they may have rate changes in October.
Mm-hmm.
Under that situation, would there need to be a special open enrollment for the entire eligible population?
There would not need to be a special open enrollment as a practical matter. That may be something you would want to do. And it may be something you're advised by you consultant to do, but you may be making a lot of mid-year changes for folks that request it.
All right, you ready for another tricky one?
Yeah, I think so.
Hey, you
This
did
is
it to
your
me with the
revenge.
examples.
I know.
This is my payback.
Okay.
If an employee is enrolled in dependent care FSA,
Mm-hmm.
but his wife also signed up for the FSA through her work,
Uh-huh.
would this allow him to stop his contributions?
No,
His selection for 2025 was 5,000, but was reduced to 3,700 due to the flexible benefit plan non-discrimination test. No.
no.
Okay, it wasn't so tricky. It was tricky for me. It wasn't tricky.
It was just a question we hadn't seen in a while, but the answer is no.
Uh, when an employee returns from FMLA, can they enroll in DCAP?
Yes.
How about if an employee is in a high deductible health plan and thought that they signed up for HSA but mistakenly signed up for FSA, can the monies be moved?
No. Well, let me think about this for a minute. Moved is a tricky question, right? Because it's two things. Can they stop? They are allowed to change enrollments in the HSA monthly. However, they are likely not going to be able to have both the HSA and the FSA that at the same time.
Could they have it at the same time if it's a limited FSA where it only is used for dental and vision,
Yes.
right?
Yes.
So,
Right.
but in that case, if now I'm just going off the top of my head, if they accidentally signed up for the FSA, not the HSA,
They could still use it.
they could use it as a limited FSA, right?
Right. And
Okay,
it
after
really
they
depends
meet
on
the,
whether, yeah, it depends on whether the employer's plans are set up to do that and whether their administrators can administer that. So that is both a legal question and a practical question. But yeah, those are the considerations there.
there are some other questions maybe you take a look through and see if there's one that you like.
Yeah, it sounds like, let me take a quick look. I hope that this is not coming up on your screen. Let me move that over. I think we may take a ride through all of these and put out an FAQs on this because there's been a lot of interest, which is fantastic, and a lot of questions, and I want to make sure that we addressed all of them. So I think we will be putting something out on this in the coming weeks.
And there are some variations on the same questions, but with little ripples that came from different people. They're all on similar things. So yeah, we will absolutely get something put together and out as soon as possible. Amy, thank you very much for your time and all the effort you put into these webinars. I always learn a lot, and I really appreciate it. I don't know how I feel about being included on camera all the time, so there's
I was
that.
going to say thank you for being such a good sport. I really appreciate having another person to talk to during these webinars because usually I'm just hearing myself speak for an hour. So thank you.
And for those of you listening, if you have a subject that you want us to cover in one of our upcoming webinars, please feel free to reach out to us. You can respond to the survey that's emailed out at the end of this webinar. That survey will allow you to tell us if there's something you want to, a topic you want us to cover, or you can always reach out to me on LinkedIn or at
Or me.
info@keenan.com or Amy.
Mhm.
And let us know. We're more than happy to explore other topics besides the ones we come up with.
So thank you.
Thank you, everyone.